Well, joining me now is retired Judge Chris Greenland. As always, great to have you with us in the studio, Judge.
Good afternoon.
I've been complaining somewhat about these adjournments. You're obviously, as a retired judge, is this par for the course that you would have a 2-week adjournment in which one presumably is preparing witnesses, making sure that everybody is lined up? I mean, it's not as if people have been taken by surprise that they're going to testify. Is this usual, this sort of, these stops and starts and stops and starts?
Stops and starts are very common. What I don't think is acceptable is the level of time lost in this particular trial. And you've correctly pointed out, as regards the last 2 days, we had a 2-week recess in order for counsel to prepare and muster his witnesses for the continuation. I mean, the courts are there at public expense to perform a function. And the question that now arises is whether there is a subversion of the functional integrity of the court. You know, Bongani, it has a knock-on effect. It means that this court is not completing this case. And the knock-on effect means that other prisoners, accused persons, have to wait. And perhaps more importantly, it means that victims have to wait that longer for justice. And of course, it's a cliched saying that justice delayed is justice denied. So, regrettably, I don't think it's acceptable. I don't think the situation that is playing out at the moment is acceptable.
To be fair, though, I mean, what can the judge do? What can, the presiding officer do if counsel tells her, the people that they had lined up for the day are finished because they anticipated cross-examination might take a bit longer? It hasn't. Sorry. What can she do?
Well, the judge is in control of the court. It's her court. And in the normal course, the judge actually controls the court and will have made ground rules quite clear to counsel. And if those ground rules can't tolerate, accept, connive or collude at time wasting or losing time unnecessarily. So if they're being breached, I would expect the presiding judge to jump on counsel.
But again, to be fair, what's in it for the defense to delay this? It's not as if the picture is going to change. It's not as if their case is going to be different by making this drag out. They wouldn't do this deliberately, surely?
I would not venture to say that there is some ulterior motive. I don't know, and I wouldn't like to speculate. But what I do know is that we have reason to be concerned.
So, I mean, how does it play out for you? Because we've also had a discussion on this channel about that, in a sense, this trial is a showcase of the South African justice system. How does it then sit with you that people are now making jokes saying, gosh, I want a half-day job, I want to be a lawyer?
Well, from a personal point of view, and a very personal point of view, because I made this point to the Judicial Services Commission, that I really felt very strongly that justice needed to be brought closer to the people. So from my personal point of view, I am ever so elated at the fact that our system is being exposed in this way by this program. And its good points and its bad aspects are being exposed. And I think this might well be one of them. It might be that there is a culture, please God, let's hope that's not the case, that there is a culture that this type of time wasting is tolerated, connived at, and colluded at. I don't know. Hopefully not. But certainly, because of this exposure, I'm sure the Judge President, it'll come to his or her notice, and action should be taken.
Let's come back to, actual proceedings then from today, what we did have. Obviously, as we've said throughout this channel and throughout broadcasting this trial, that really the only decisions that are important are those that are going to be made by the judge. And to that end then, we heard today witnesses or ear witnesses trying to mimic sounds that they heard on the morning in question. How does that play out from an emotive point of view? How do those theatrics, if you like, of witnesses wailing, trying to remember what they think they heard?
In deciding the issues in this case, the court is concerned with matters of fact primarily. There is law involved, but you first have to establish the facts to decide how they're resolved in law. So these sounds are a matter of fact that have a bearing on the case. And what I found interesting today was that Mrs. Lengetwa was asked to demonstrate the sound that she heard. And she did. And was at pains to point out the rider, but he sounded like a man. We must remember, Bongani, that it was always said that the evidence of Michelle Berger and the Stips was explicable on the basis that Oscar sounds like a woman. And here you had a defense witness saying, no, it is high-pitched, but it sounds like a man.
Well, not only Mrs. Nklengetwa, but Mrs. Mutswane as well, who testified after her, was also asked to mimic the sounds that she heard. And she was also quite clear that, yes, it was high-pitched, but it was the sound of a man.
Yes, and I therefore am bemused from the defense point of view on this aspect of the matter.
Again, my difficulty is that the areas in which Oscar Pistorius seemed to have the most difficulty under cross-examination were really around the key elements of this case. These are the areas that presumably would have been backed up by the science, by the forensics, by the ballistics, by the experts. Where are the experts?
Bongani, I share your bemusement on this, because this evidence over the last 2 days, with the greatest respect, in my view, doesn't take Oscar's case anywhere or very much further. The state has never disputed the fact that after the shooting, he was in an extremely traumatized state, and that he cried, whimpered, etc. And that's all the defense have led, because their evidence has to be reconciled to the known facts. And it's quite obvious that if one reconciles the evidence of the Hlengwetas, the first time they become aware of the facts at issue is a bang. Must have been either the door being banged, the last time being opened, or the last shot. So there is nothing about their evidence that embarrasses the state case, because it's supposed to embarrass the state case if it could exclude Riva screaming. But of course, with that last shot or the last bang, she was already incapacitated and in the throes of death. So their evidence, to my mind, doesn't take this defense case any further, except to further confirm that Oscar was in a highly traumatized case, and therefore to support the argument that this wasn't a man that could have just performed a cold-blooded killing.
Is there a strategy that perhaps you can see that we as lay people might not be able to perceive, that these were the people that would be brought almost first up? I mean, I know we've had Dixon and we've had obviously Botha to testify as experts, but outside of Oscar Pistorius, is there some kind of plan here to bring lay people, the ear witnesses, first, before then you bring in your forensic specialists and psychologists and whatever other experts one has lined up if you're the defense?
Not that I can see, but of course I'm not Barry Roo, and I would not presume to second guess him, except to say that I don't see where the defense is going at the moment. I would have thought that it is critically important from the defense point of view, to call the psychologists and or the expert evidence.
One last quick question, if I may. What about the issue of the witnesses that we have seen in the last 2 days, having had access to the proceedings through watching it on television, because their understanding was that they wouldn't be called?
Well, I wasn't sure that any of them said that it was their understanding that they would not be called.
Well, certainly Mrs. Mutswana said she'd even SMS'd to say, am I still going to be called? Am I free to watch? And all three of the ones we've had to, in the last 2 days said they'd watched.
Well, I didn't see her giving evidence because I was driving to the studio. But as regards the Tlengetswas, I didn't pick that up. But I think it had a little bit of an unfortunate effect as regards Mr. Tlengwate, in that he therefore was very defensive when he was being questioned. He was inclined to want to explain things quite unnecessarily because he was being reminded of the fact, these historical facts that you've just referred to.
All right, Judge, as always, thank you for your insights. You and I are going to continue chatting throughout the afternoon.
Thank you.
As always, great to have your perspective.
Thank you.